Welcome to our next module in our employment law course. We're talking in this module about how our legal system works and also about the employment at will doctrine. We kind of got introduced to this doctrine when we were in our first module, but we'll do a significantly deeper dive at this point in time. So let's begin. Again, for this PowerPoint, we have 3 topics. And I'm going to focus on this first topic, which is basically an overview of how our legal system works. In subsequent lectures, we'll talk in more detail about the employment at will doctrine. And so let's begin. Now, I'm going to be honest with you. We always like to do this type of presentation in paralegal courses because our program doesn't have a lot of prerequisites. And so some of the students who are taking this course, this may be their first semester in paralegal course. So their knowledge about how our legal system works may not be very sophisticated at this time. So if you happen to be one of those folks who this is your first semester, you're going to want to watch this carefully. And if you have questions, come see me. I'm not going to spend a ton of time on this, though, because most of the people in this class have heard the same spiel again and again. So again, if I'm going too fast, feel free to stop by my office hours or perhaps watch the presentation a second time. So let's begin. So when we think about our legal system, there's lots of moving pieces. There's lots of different ways of unpacking the concepts that we're going to be talking about. And so one way that you can think about these topics is you can compare civil law with public law. And sometimes people call civil law private law. And many times when we talk about civil law, we're talking about things like torts or contract claims or things like that. In this course, we're going to be focusing on civil law, not so much public law, although sometimes public law issues will come into play. And that's typically when someone from the government kind of gets involved in a situation. In this course, we're going to be focusing on substantive law. Substantive law is the what our rights are discussion. So you could say what it answers the question of what rights and responsibilities do I have. Procedural law is about how can I enforce those rights in our legal system. And so there will be some discussion of how, but I would say probably 90% of our course will be about what our rights are. Our main procedural class is going to be civil litigation, which is LGLA 1345. That's our real course that we focus on procedural law. Then, of course, we talk about primary source of law versus secondary sources of law. Actually, in our first lecture series, we did talk about the distinctions and we focused on the primary source of law. Again, in this course, we're going to mainly spend time on the primary source of law. For this course, those are mainly going to be statutes, regulations, and case law. But there will be some times that we talk about secondary source of law. For example, one secondary source of law is your textbook. Another secondary source of law is our lectures here. So we'll be using lots of secondary sources to help us understand the primary sources. And of course, federalism is a big issue in employment law because we have federal law, which of course we have to comply with, and then we'll also have state law, in this case obviously Texas law, and sometimes even local law. And so we'll talk about how those two sets of laws work together and what we do if there's a conflict between those. So those are some important organizing precepts. As I said before, civil law has to do with private disputes. Again, this is what the vast majority of our area is going to be about. This is mainly employment law. But sometimes you have situations where a person is an employee of the federal government or the state government. And so you can have public law implications from time to time. There can be situations in which the EOC, for example, decides to sue on behalf of an individual because the EOC thinks that that individual was subject to employment discrimination. So there are some shades of public law, but for the most part, we're talking about civil law. That's, I'd say, would be 80 to 90% of the topics that we'll be dealing with, if not even more, higher percentage than that. Okay, a substantive law, again, this answers the question of what. Procedural law answers the question of how. And again, for the most part, we're focusing on this topic. But when it's a unique aspect of employment law, I will point out those aspects of procedural law. So we're not going to talk about the aspects of procedural law that are the same for employment law as would be in a tort case or a contract dispute. I will, however, talk about the aspects of procedural law that are unique or at least distinctive to employment and labor law. So we'll talk a little bit about procedural law, but not do a very deep dive. Obviously, if you have questions about procedural law, please feel free to stop by my office hours. I'll be delighted to talk to you in more details about that. We've already talked about primary source of law, but the way to distinguish between primary and secondary sources is a primary source, someone in the government is telling us to do something or not do something, or we have the right to do something. So it is an official from the government acting in his or her official capacity saying that. So it could be the president, it could be the governor, it could be someone in the legislative branch, it could be someone from an administrative agency, or it could be a judge. All of those would be primary source of law. And again, here are the examples that we talked about in an earlier presentation. Secondary source of law are things that don't fit into the primary source of law. So they're going to be things from somebody other than a governmental official. And they really help us do one of three things. They can help us find the law. They can help us understand primary sources. They can help us find primary source of law. They can help us understand the primary source of law. And they can help us evaluate the importance or significance of that primary source of law. So as you probably have gathered, it can be quite difficult to find primary source of law, especially if it's case law, because case law is organized chronologically. It's not really organized by subject. So we can pretty readily see the decisions that came down yesterday, but it is somewhat challenging to sort through and find the decisions that relate to criminal law, and then put the decisions that relate to contract law in a separate bucket, and put the decisions related to family law in a separate bucket. In addition, then we'd want to drill more granularly down to talk about the particular issue that we're concerned about related to contract law, or the particular issue we're focusing on for family law. And that drilling down process oftentimes happens with secondary sources. And of course, one of the big secondary sources that we use in this course is going to be Westlaw. And we'll be talking in more detail about how we use Westlaw, when we use Westlaw, and what the tools are available in Westlaw. But there are other resources, such as these lectures and the textbook, that are going to help, and of course our Canvas classroom, that will help us find these resources. So as you look on Canvas, you'll see, for example, I have links to various statutes. So that link is a secondary source of law. It isn't actually the law, but it helps you find that law. Other resources that we use, such as these lectures and the textbook, can help us understand the law. This course would be a lot less user-friendly if I were to just give you the statutes and say, okay, here are the statutes, learn them, and there'll be a test next week on them. The statutes are very difficult to understand. It takes a lot of experience with them to be accomplished at reading them. And even when you're experienced, it's still a slow process. And that's one of the reasons why we have so many cases, because there's a dispute about what a particular statute means. And so the judge has to resolve that level of ambiguity. So in addition to reading the statute, you also have to be familiar with the cases. And you have to know what the cases are. And that's my job, to point you to the statutes, to point you to the cases that are important. And I'm also there to evaluate. I don't give you 1,000 cases to read, although there's way more than 1,000 cases in this practice area to look at. I point out a few that I think illustrate a point or are especially important. And so that's how secondary sources work. Unlike primary sources, those secondary sources are not inherently important. I mean, a statute is important whether you agree with it or not, because you have to comply with it or face the consequences of not complying. But secondary sources can be bad or outdated, and they can misdescribe or mischaracterize the law. Or maybe they're referring to an earlier iteration of law that isn't even in effect at this point in time. So in those cases, a secondary source can be unhelpful and in fact misleading or harmful if it indicates that the law is a certain way versus another way. I'll give you an example. There's been a fairly recent Supreme Court case that has reinterpreted a section of Title VII. When I initially designed this course, I had the more widely accepted definition at that time of a section of Title VII. And but when the U.S. Supreme Court came down with this decision, that obviously caused me to want to change the material that is on Canvas, that is in our textbook, and that is in our lectures. And so if I had not made that change, the secondary source of law, the textbook, would have been a really bad source of law because it would tell you things that weren't true. And so secondary source of law need to constantly be updated to reflect the changing kind of living nature of the law. So examples again are things like textbooks, non-governmental websites that try to describe the law. We've already looked at least one restatements of law that defined what agency was. West Key number system, we'll be working with that when we deal with Westlaw. Things like legal encyclopedias and dictionaries, again, these are available in Westlaw as well. And Keysight and Shepard's. A Keysight is a Westlaw tool that we will have access to. Shepard's is a Lexis tool, which is equally good, that helps us work with citation. We're not going to spend a lot of time with citation this course. You'll find out more information about citation, especially in legal research, to some extent in legal writing, and also to some extent in introduction of legal conventions. So this won't be a major topic, but it is an important source of secondary law. Again, this is not an exhaustive list, but this gives you some ideas. Now, sometimes people get the impression when I have this explanation, the secondary source of law are somehow bad or not as important or not as good to use as primary source of law. And to some extent, that is the right impression. If you have a choice between using a primary source of law and a secondary source of law, almost always you're going to go with the primary source of law. Having said that, secondary sources of law can save you a tremendous amount of time in understanding the primary sources. I'm assuming that your secondary source is vetted and is a good secondary source. You can save a tremendous amount of time, and that saving of time can be tremendously helpful in terms of saving your client money, because in a legal profession, time is money, literally, because we bill based upon the minutes. So secondary sources of law are very, very important for the functions that they do well. In fact, they're better at finding law, better at understanding law, and better at evaluating law than primary sources. But at the end of the day, when it comes time to cite the material, in most cases, you're going to rely upon the primary sources. So I wouldn't say primary sources are better or more important than secondary sources. I would say they each have a really important role in this process. And especially when you're learning about the law, secondary sources are really, really helpful. As you can see here, we've already talked about a few definitions. Let me just go ahead and flag those. Again, we have our definition for civil law. If I were putting this into my Quizlet, I would include all of this in my Quizlet. Then we have public law. Again, all of this down here would be part of my definition for Quizlet. Substantive law, I'd probably include all of this in here. I think it makes it a lot easier from a brain organization standpoint to remember the word what with respect to substantive law. With procedural law, again, we have the same issue. The key word is how for procedural law. So I would include both parts of that in my Quizlet. And again, for primary source of law, I would include this whole thing in the definition. And I would probably flag the word government. Somebody from the government's developing this. It's also a good idea, this Quizlet may not be the place for this, but it may be, is to list the primary sources that we have. If you wanted to, you could list, you could have federal and state constitutions as one of your elements, and then in the definition say a primary source of law. For statutes, you could say a primary source of law. These are important to be able to identify, and so you may want to use some tool like Quizlet to help you with that function. Here we have our secondary sources, and this would be a good definition. You can also define it as not a primary source, obviously. And then here are some good examples. You may want to use some kind of, example like textbooks, treatises, and hornbooks that say, as a definition, a secondary source of law. Okay, so let's go on. Now we're going to talk a little bit about federal law versus state law. The U.S. Constitution is obviously our organizing principle in terms of how our government runs, and there's a clause in the Constitution called the Supremacy Clause. You can see it's in red, so you know you're responsible for it. You absolutely don't need to memorize it, but the Supremacy Clause has a phrase in it saying that the laws of the United States, so here we're talking about federal law, not state law, are supreme. Are the supreme law of the land. So this could be, if I were going to come up with a definition for Supremacy Clause, I would identify it as something from the U.S. Constitution, and I would say that the U.S. Constitution and federal laws are supreme over state laws. And this takes us to the issue of preemption. So let's go forward and talk a little bit about preemption. So preemption is the idea. Let me just write out the word. Maybe I have it on the next slide. I don't, okay. Preemption is probably a word that I would, if I were you, add that to my Quizlet. And preemption has to do with which law takes precedent, which law comes before. You can see preempt means to go before, or to, in some sense, cancel that other activity. And so the question when you have a state law and a federal law that are not consistent with each other is which controls? Do I follow the state law or do I follow the federal law? Well, we've largely gotten the answer here with the Supremacy Clause. The federal law in most cases is going to trump or preempt the state law. That's true the vast majority of the time in the employment law arena. It's not always true in other practice areas. Now, when we say the federal law preempts, that's a little bit misleading, because actually, you look at the statute, because even though the federal government has the authority to preempt, it pretty routinely says we don't want to preempt. And in fact, in the employment law areas, I discussed in an earlier lecture, in most cases, the Congress has said, look, we understand we have the power to preempt state laws, but we don't want to. If the state law is more generous than federal law, we're perfectly fine with the state having that more generous statute. We see the federal law as providing a floor, but a state can do more than that floor. If it wants to, it can't do less. It can do the same or it can do more. That's the federal policy in most statutes. Now, that doesn't have to be the law. The Congress would absolutely have the authority to say, this is the floor and the ceiling. A state can't offer more benefits, can't offer less benefits. But that hasn't been what we've seen in most statutes. Now, the issue of preemption in the employment law area in the state of Texas isn't much of a big deal, because in Texas, in most cases, either there isn't a state law that conflicts with the federal, or that even discusses the same topic as the federal law, or the Texas law mirrors the federal law. there are relatively few places where the Texas law provides more generous benefits. Since we know federal law is always going to provide that floor, the only time that we would be interested in preemption would be when the Texas state law provides greater benefits, and then we wonder, well, is that law in effect? Is that law not been preempted? And as I said, in most cases, it won't be. Now, there is another issue to talk about, and I'm going to talk about it very briefly because it's really not relevant to this course. But since I'm talking about the topic of preemption, I don't want to mislead anybody. And while I said that the federal laws preempt state laws, that's not 1,000% true in every single circumstance. When you look at the U.S. Constitution, there are certain areas that the Constitution says, that's the job of the federal government. And there are other areas where the U.S. Constitution says that's the job of the state government. Or sometimes the Constitution doesn't opine one way or the other. Doesn't say whether that area is for the states to control or for the federal government to control. So for the federal government to act in a particular area, it needs to point to something in the Constitution that gives it the authority to do so. And it's what's called an enumerated power. So if let's say that the Congress wanted to establish, we'll say something silly, it's obviously not going to happen, that the Congress wanted to establish a law that said you had to be 25 before you get married in any one of the 50 states. Well, that isn't an enumerated power. And so I think there would be a very good argument that Congress can't pass that law. It doesn't have the authority to pass a law, that is one of those areas of responsibility that has been reserved for the states, even though there's nothing explicit about that in the Constitution. And so the federal law would be unconstitutional because it's outside of the purview, the area of responsibility of the Congress. So when you find an area that Congress passes a law that is really outside of its area, then it would not preempt a state law. And there have been cases on just this point. If you follow constitutional law, you may recall that there was a lot of debate about whether the Affordable Health Care Act, also called Obamacare, was constitutional or not. And the reason why it was at issue was this very issue. Did Congress overstep its bounds when it legislated or when certain aspects of that legislation was passed? And the U.S. Supreme Court concluded that, yes, Congress did act appropriately, or at least within its power to do so in most respects. There were a couple of details that were beyond the purview of the Congress, but for the most part, it agreed that Congress had that authority. Okay, so that's an example. Obviously, you aren't responsible for any, well, actually, we will talk a little bit about the Health Care Act at the very end of this course, but for now, you don't need to know anything about the Health Care Act. I offer that simply as an example. Okay, so let's go forward. Let's see, I think I've pretty much covered this. Here's an example, and again, this is a slide I should have updated, I apologize. When I prepared these PowerPoints initially, sexual orientation was not a covered category under Title VII, but in many states, about half the states, or about half the population of the United States, not quite 50% of the states, sexual orientation was considered a protected category under state law. That wasn't the case in Texas. It wasn't covered in Texas either under state law or at that time under our understanding of federal law. But because of recent U.S. Supreme Court cases, we now know that sexual orientation is a protected category under Title VII. And so that should not have been. So if you would, in your notes, be sure to cross this term out because this is sexual orientation is a protected category in all 50 states now. But marital status isn't, and there are some states that do provide marital status protection for individuals in those states. And that's an example, again, of how the federal government says, or the Congress says, states can provide more protection, just not less protection. Here we go. Okay, so now we're going to talk about another aspect of our constitutional system, and that is checks and balances. Many times people conflate or confuse checks and balances with federalism. Federalism is this preemption stuff we talked about. Here's another term that if you don't already have it in your wheelhouse of vocabulary, you'll want to add it. And federalism is a term that compares the authority of states versus the federal government. And since the founding of our country, there have been this tension between our federal government and our state government as to which one has an authority to do this versus that. And the balance of power has evolved significantly over time. And it continues to evolve. Even during the years that I've been practicing law, I've seen changes and shifts in this level, or this relationship as to who has a certain amount of power. And so that's what federalism is about. Checks and balances isn't about state versus federal. It's about within the federal and also within the state. So within the federal branch, we have the federal government, we have three branches. We have the legislative branch, we have the executive branch, and we have the judicial branch. Now, I'm not putting these in red, but if you are unfamiliar with the role of the executive, legislative, and judicial branch, it may be useful for you to go ahead and add this to your Quizlet list as well. But again, the checks and balance is the balance between the legislative, executive, and judicial branches. So again, this would be a good term to add to your Quizlet. Now we have these three branches in both the state government and the federal government. So the checks and balances issue exists both on the national level and on the state level. And if you think about this conceptually, the legislative branch is a check on the executive branch. The legislative branch is a check on the judicial branch. The judicial branch is a check on the executive branch. The judicial branch is a check on the legislative branch. And the executive branch is a check on the legislative branch and also on the judicial branch. They all have a check role with respect to the other branches. Let me give you an example. The legislative branch passes a law. The executive, be that person the governor or the president, can veto that law. So that's a check on the authority of the legislative branch. The judicial branch can opine about whether that piece of legislation was constitutional or not. So that judicial branch has a check on the legislative branch. The executive branch is a check on the judicial branch because the executive branch appoints judges to the federal government. Now that doesn't exist as much in the state system as it does in the federal system. And the legislative branch has the also authority to advise and consent in terms of the selection of judicial branches. They have to vote to approve the nomination of the executive in his or her choice for the court. And of course the judicial branch, the legislative branch can be involved in impeachment of judges. So as you can see, all three of the branches have a role in making sure the other branches stay well behaved, we could say. And of course, this reflects our founding fathers' concern about the possibility of despotism and tyranny. And so these checks were designed to keep kind of everybody in their lane doing what they were supposed to do. The executive branch includes law enforcement capacities. It's of course headed by the president or the governor. But for our purposes, we would focus on the administrative agencies. Administrative agencies are super cool things, they really are, because within most administrative agencies, you have all three of these functions. Administrative agencies come up with regulations, which is very similar to legislation. They enforce those rules. They investigate alleged violations, which is the executive function. And they also have administrative law judges who render decisions about whether a particular law or regulation was violated. So within most administrative agencies, you see these same checks and balances on a microcosm level. So it's an interesting thing. So you'll see that those functions in the Department of Labor, as well as the Equal Employment Opportunity Commission, and for that matter, the National Labor Relations Board. And you'd also see these same things on the state level as well. Okay, so now we're going to talk about case law. When we go through this course, you may be tempted at times to think everything is case law, because that's where we're going to spend most of our time, to be honest, talking about. But of course, most of the case law we're going to be talking about involves interpreting statutes. So lurking behind those cases are statutes. That's what the judge is looking at. That's what he or she is focusing on. And so when a court interprets a statute, we usually don't think of it quite as the traditional type of common law. But when a judge doesn't have a statute to work from, he or she is considered to be looking at the common law. Let me just draw you a picture here of the common laws. This is going to seem very familiar to those of y'all that this isn't your first semester. Imagine that you had a world, well, let's go back to, say, 1300s England. And we're in a small hamlet somewhere. Most of us in this hamlet don't know how to read or write, don't have any formal education. And we're just trying to survive from day to day. There's plagues, there's famines, there's droughts, there's all kinds of problems that occupy most of our time just to survive. And frankly, our life expectancy isn't very long. And so we're not spending, and our little hamlet doesn't have a lot of communication in the outside world. It's dangerous to go from town to town. There's bandits out there and criminals and things along those lines. And so the roads aren't very good. The means of transportation aren't very good. So towns typically didn't have a lot of interaction, say, with London or other cities. They were kind of off by themselves. And in that situation, you can see how there really wouldn't be a lot of law that would exist. People just didn't have the time or the education or the luxury to have a very sophisticated legal system. So what would happen is a dispute would arise in that community. And somebody would have to solve that dispute. Perhaps it was the lord of the manor, perhaps it was the priest in that community. Or maybe it was a wise person in that community that everyone kind of trusted to make the good decision. And so this dispute between neighbors would come up, and then that person who had authority would render a decision. He or she would decide, usually be a he, so I'll say he going forward. He would decide that this is how we're going to solve this issue. This is the type of evidence we're going to consider. This is how we're going to weigh the evidence. Well, once that precedent or that practice was established, then everyone kind of had that expectation. So when a similar dispute arose, kind of on the same topic or close to the same topic, everybody said, well, let's just do what we did last time. Let's follow that rule. Okay, well, if we follow that rule, this is the result. And so over time, these traditions became more and more well established and developed into the force of law. And that is what common law is. Common law was a system probably everywhere, really, until people became, I guess, sophisticated enough or had enough resources to actually codify or put into books the legal standards that they had established. Probably the most famous codification was the Napoleonic Codes, and that happened in the very early 1800s. And it was one of the tools that Napoleon did to unite his empire. Everybody was following the same rules, the same laws. And when he would conquer a country, he would implement these laws. And as a result, we see throughout continental Europe and also Latin America, as well as some other places, remnants or even more than remnants of the Napoleonic Code continues to this day. But of course, Napoleon didn't conquer England, and so therefore England continued to have its common law tradition. Now, of course, as time passed, there did get to be some statutes. And so the gaps in the law became less pronounced. And anytime, of course, the legislature rendered a decision, not rendered a decision, but passed a law, that law would replace whatever that previous tradition was in that community. So laws trump the common law. Statutes trump the common law. But the reality is, in most areas, the common law is still our system of doing things in the United States. Again, because of our connection with Great Britain. A good rule of thumb is if a country was once part of the British Empire, if English is a major language in that country, for example, probably they have a common law system. So we see common law systems in countries like Ireland, Australia, South Africa, India, the United States, Canada, and several other countries. Now that doesn't mean we don't have statutes, obviously we do, but we have a reliance on these legal traditions that's quite a bit more strong than you would see, say, in France, which has a Napoleonic code. The reality is, in our system in the United States and Britain and in most of those other countries that I just mentioned, nobody ever sat down and said, let's develop a systematic code that's going to address every issue we can think of. That's what the Napoleonic Code did pretty successfully, but we've never done that. We have developed statutes on a kind of an ad hoc basis. Some member of the legislature says, we need a law for that. Okay, let's pass a law. But what doesn't happen is the person doesn't say, we need to come up with a systematic, exhaustive answer to all of the questions in this particular topic. Now, I say we haven't done that, but that's not completely true. For the most part, our penal code, which is our criminal code, is pretty much of it derives from the common law, that the principles that we see in the penal code are ideas that develop through our common law tradition, but it is designed to be a pretty rigorous code that addresses most issues. So we do have some aspects of that civil code mentality, even in our common law system. But we are, for sure, most definitely a common law jurisdiction. And so, generally speaking, when we're talking about contract law, we're talking about tort law, we're talking about the common law. And again, we don't have a ton of common law in this course, but we do have a lot of importance upon judicial decisions. In a civil code jurisdiction, which is what we're a common law system, a civil code system is the alternative. That's like what we see in Latin America and what we see in France. It's also what we have in Louisiana, because of course, Louisiana was part of France before the Louisiana Purchase. So the civil code system is the alternative to the common law system. One thing that you'll see in a civil code system is that judges have a much smaller role. They don't make law like we have in the common law system. Plus, precedent really isn't very important in a civil code system. In other words, if I have a dispute with Bob and we go to the judge and the judge says Bob wins, and then 10 years later, Larry and Teresa have a dispute over that same topic, Larry and Teresa are probably not going to pay too much attention to this decision that the judge made in Bob's and my dispute. The judge really is just rendering decisions for the two litigants in a civil code system. In the common law system, what the judge decides becomes law. It becomes one of these primary sources of law. And the idea that causes that to happen is stare decisis. I talked about this in an earlier lecture, so I'm not going to spend more time than we did before. But I do want to point out that it does give stability and predictability to the law, because we now have an answer to that question. It may not be the best answer. The judge may have messed up. But of course, if the judge did mess up, the legislature can come in and replace that precedent with a new statute. And then the precedent goes poof, it's no longer the law of the land. So the common law system does definitely have strengths, but also the civil code system has strengths. We're not going to change. So if you're wondering if we're slowly becoming a civil code system, I don't see that in our future. So here's information about how our court system works. And most employment law cases do go through our federal system. Our federal system handles about 10% of the litigation that happens in the United States. 90% goes to the state court system. But in the area of employment discrimination, the significant majority of cases go through the federal system. And that's especially true in a state like Texas that doesn't provide additional protections in most cases to employees. The federal court system, many people almost say this somewhat jokingly, but it's not completely untrue, that the federal court system is largely become an employment law court system, because a very significant portion of the docket in federal courts are the employment cases. So how does the federal court system work? It works like this. So we have lots of district courts down here. District courts are the trial courts in the federal system. So in these courts, we have a single judge. He or she had to be nominated by the President of the United States and approved by, district court, has to be approved by the Senate. And then he or she has a court, and that court will hear jury trials. For the most part, sometimes bench trials, sometimes judge-only trials, but for the most part, bench trials. And so the district court is the first place you go when you're the plaintiff. If you're not happy with what happened in the district court, then you go to the appellate court. And we happen to have, 13 courts in this system. Now, the term court is a little bit misleading because there are multiple courthouses in the 13 district circuit courts. There's multiple courthouses, so it's not like there's just a few judges in each one of these courts. There's lots of judges in each one of these systems, and so that's where you go for your appeal. So if I'm the plaintiff and I lose at the district court level, I can appeal to my appropriate circuit court. I also have that right of appeal if I am a defendant, so that's circuit court. There's another term for circuit court, and that is appellate court. Both terms are commonly used for this particular court. They're interchangeable. And then, of course, our final court, and we just have one of these, is the U.S. Supreme Court. And again, if I'm not happy with what happened in the circuit court level, I can go to the Supreme Court. We have a similar system for state courts. Again, because most of our litigation is going to happen in federal court, I'm not going to spend a lot of time talking about this, but it's the same system in Texas as we do have in the federal system. So here's a hierarchy of authorities. Obviously, the U.S. Constitution is the most important authority. Everything that happens has to be compliant with the U.S. Constitution. Then the next level authority is a statute. If a statute is constitutional, then it's what controls. We only look at common law when the Constitution is silent on that issue and there is no statute with respect to that issue. Okay, so that's the pecking order. Sometimes people forget this and think, well, the common law could trump a statute. No way that could happen. I mean, the only way it could happen is if the statute were unconstitutional. Going back to that idea of federalism, the federal court system those judges are not going to comment upon or interpret a state statute as a general matter. They're not going to do that because that's not their thing. That's not one of their enumerated powers. Federal judges can opine, can comment, can interpret federal statutes, but state statutes, those need to be interpreted by the state court system. The one exception to that is if a state law were to violate the U.S. Constitution. But at that point, the federal court system, that judge is interpreting the U.S. Constitution, which is obviously a federal document, and they're only indirectly opining about the state statute. So this is another important fact. So when we do talk about state statutes, we're going to look at state court opinions. Well, it's always important when you're doing research to stop and think, should I be looking in federal resources or should I be looking in state resources to make that analysis? We talk a lot more about this topic in legal research. So again, if you have questions about it, feel free to pop into my office hours. I'll be delighted to discuss it with you. For the most part, you'll get more information about that in the legal research class. So here we have some more terminology. Adjudication, you can kind of see in the word adjudication the word judge kind of lurking here. And of course, this is the process by which a judge renders a decision. It's a legal process by which a court or an arbitrator applies the law to facts determined by a fact finder. Okay, usually in our system, the jury is the fact finder, but the judge is ultimately responsible for the adjudication or resolution of the case. Let's consider very briefly the topic of jurisdiction. Again, you will learn much more about this in the Introduction to the Law course, LGLA 1307, and also 1345, the Civil Litigation course. So I'm not going to do a very deep dive. One of the assumptions that we have in our system, because we have these two court systems, we have the state system and the federal system. The assumption in our system is that cases ought to go to the state court system. That's the default setting that we have that kind of built-in expectation. As I said earlier, about 90% of all litigation does go through the state court system. So the litigant, the plaintiff, needs a special reason to justify the case going into the federal system. And there are two bases that are usually the basis for the case going into the federal system. This is not an exhaustive list. I've just picked the two most important categories. And the first is the federal question. And that means that there's a dispute arising under federal law. And this could be a federal statute or the U.S. Constitution. Now, this is the one that's most important to our class because most of the statutes we're going to be talking about, like almost all the statutes we're going to be talking about, are federal statutes. In other words, they're things passed by the U.S. Congress. And in that situation, if the U.S. Congress passed the law, then we ought to be in federal court to resolve that issue. So the basis for jurisdiction for most employment law cases is going to be when a federal question is raised. And again, when you see the word question in this context, it's a question about a federal statute. So it has to do with a statute or sometimes a constitution. But again, for our class, it's usually going to be a federal statute. The other way you can get into federal court, this is actually the single most common way to get into federal court, is based upon diversity jurisdiction. And you will sometimes see cases in our area that do get into federal court based upon this. And probably even more commonly, both of these reasons independently are justification. You just need one of these reasons, but you sometimes will find that you have two. The first requirement is the amount in controversy must be over $75,000. That's not a very high threshold, so usually that's not the issue. The second part is that the litigants have to be from different states or different countries. This is a really complicated subject. There's courses in law school that spend weeks and weeks on just this topic. So what I just said is so simple that it's in some respects misleading, but for the purposes of this class, you don't really need to know more than that. Just know that by making it so simple, I have, in some sense, mischaracterized the issue just a little bit. So understand it's a much more complex issue that I'm suggesting. Here we have some vocabulary. Again, be sure to include these in Quizlet, especially if you're not familiar with them before. You probably know plaintiff and defendant, but you may not know appellant. And you can see appellant ends with A-N-T. Sometimes when we say this in English, we don't really make the N sound. So it can sometimes sound like this word, appellate. When people say appellate, they usually don't emphasize the ate. They say appellate. So appellate and appellant can sound very similar, but they have very different meanings. So it's important to know which one of these words that you mean. Appellate refers to the appeals process. It's neutral. It's not on either one of the parties' side. So it's appropriate to talk about an appellate court, or an appellate judge, or an appellate process. But the appellant is partisan. He's on one side, he's on his own side, right? He's the person who's unhappy with what happened at the trial court level. He may have been the plaintiff and he lost at the trial court. He may have been the defendant and he lost in the trial court. Sometimes the appellant is called the plaintiff of the appeal because he's mad. He's unhappy with what happened. The appellee similarly can be the plaintiff or the defendant. The appellee is the one who's happy with what happened in the trial court level, and he or she wants that to remain the decision. So sometimes the appellee is called the defendant of the appeal. As you go to a higher level, to the ultimate court in that state, be it the Texas Supreme Court or the U.S. Supreme Court, we have the petitioner and the respondent. The petitioner is like the appellant. The respondent is like the appellee. So that kind of goes to that terminology. A case citation is the volume. Let me see that number first. The reporter, and then the page number where the case begins. It is basically a system to let you know, or let the reader know where to find this particular case. We have abbreviations for reporters. Reporters, by the way, are the books where case decisions are printed. So these are the court opinion books where all court opinions are published. And again, you'll learn more about this, especially in legal research. A motion to dismiss is a really common motion to file. Well, I wouldn't say really common, that's too strong. It is a relatively common motion to file. And you probably can tell by its name what's going on here. It's when it is filed usually early in the case, and the person filing it, typically the defendant, is going to be requesting that the court dismiss or delete, cancel the plaintiff's case. Usually because there's a problem with the initial documents that the plaintiff filed. If the court grants the motion, then the plaintiff is going to have to start his or her case from scratch, from the very beginning. Sometimes the problem with the case is so fundamental that the plaintiff can't restart it because there's a fatal flaw to the case. But sometimes it's more a matter of a T wasn't crossed or an I wasn't dotted, and it's possible that the plaintiff, by refiling it, can fix that particular problem. A more common motion to file, and this one really is very, very common in federal court especially, is a motion for summary judgment. This is also filed before trial, but it's usually filed later in the case than the motion to dismiss. And in this situation, typically it's the defendant, although in theory it could be the plaintiff. The defendant is saying, Your Honor, it's not possible for the plaintiff to prove his or her case, so you ought to just go ahead and dismiss the case now based upon the evidence. And that way we don't have to go through the time and expense of a trial. And if the judge, of course, grants this motion, then what happens is typically the plaintiff is going to appeal that grant, especially if the plaintiff disagrees with it, and probably the plaintiff does, and the plaintiff has the possibility of winning on appeal. If the plaintiff wins on appeal, then the case goes back down to the judge for a trial. Obviously, the judge can deny that motion, and in that case, the trial goes forward. Another term is procuring. You see I have this in italics because it is a Latin term. It literally means by the court. This is a decision that issues, typically this is a panel situation where there's more than one judge on the court, and it is being issued as a group. All the judges are signing off on the opinion. In most judicial opinions, the judge who wrote it, his or her name appears in the opinion. And it'll say the other names of the other justices or judges who are joining the particular opinion. They didn't write it, but they're saying, yes, we agree with it. In a per curiam opinion, we don't know who actually put pen to paper to write the opinion. Oftentimes this is done when it's a very routine case, and not a lot of time or effort was spent on writing the opinion, so the person doesn't really see the need to put his or her name associated with it. We won't see a lot of per curiam opinions in this particular course because we're going to be talking about the most important cases. So those were sufficiently important that the author of the opinion is definitely going to use his or her name as the writer of the opinion. Okay, so at this point, we've started the process of learning about our legal system. And in the next lecture, we're going to drill down and talk in more detail about what is employment law. Thank you for your attention. I hope you have a wonderful day. Take care.